still busy with photo number. I think we had gone up to, we're done with 46. As it please the court, my lord. The court requested that those photos that Brigadier, that the witness referred to, should be beamed contemporaneously.
So those are the photos?
Yes, my lord. I think that is photo number 12, photo number 17, and photo number 46. This was done at the request of the court.
Yeah, but Brigadier must testify about that.
Yes, my lord. So, my lord, what I said, this is picture 12, as Advocate Minister has correctly put it, my lord, which was taken on the date of this incident, 26th of October, 2014, and there's a time there, we say 17:31 and 14. Then and this picture, my lord, depicts, as I've said, accused 3 with dreadlocks going up to the neck, the khaki top, and then the second photo, my lord, taken on the very same day as well. The time on this one is 17:28:39. I suppose it's seconds, but I'm reading it as it is, my lord. Then in this picture, the dreadlocks, and this is the part we dealt with, are longer, and the accused on this, accused 3 now here, my lord, I said, this is where you can see clearly that the top that is wearing goes up to the waistline. And I said, my lord, in this regard, it correlates with the witnesses who said the suspect A, or the first intruder, was wearing a top which was described as khaki, beige, brown, along those colors, my lord. And then I also made reference to accused 5 as being present in this picture. Then when we move to picture number 46, my lord, I then said this is accused 3, and the length which Advocate Minister asked me is that it was longer, but what was of importance, of prudence, my lord, I've said the date which is reflected on photo 46 is the same date as the ones reflected on photo 12 and photo 17. In other words, the date of 26 October 2014. However, my lord, I've said in photo 46, accused 3 is dressed differently. So if you look at the type of clothing he is wearing here, is not the same as the one that you'll find in photo 17 and 12, which gives an indication that there was some changes. And now I've made reference to the fact, my lord, and this is what I've said also, that one will not know, this is what I've said, how the hair or the hairstyle, the dreadlocks, were worn by the accused. You know, I'm saying if you look at this picture physically, because that's why I said I can only rely what I see. What I see is that in photo 12, the dreadlocks are up to the neck. It's there, it speaks for itself. Here they are longer. However, between this picture and the one photo 46, my lord, there's time differences. Photo 46, one does not see the time except the date. However, on this one, there is a time difference of about max, like Advocate Minister says, which I agree with him, max 3 minutes. But a lot can happen in 3 minutes. So the length of the dreadlocks, my lord, it's clearly not the same. But I do not know what happened in between, my lord.
Kule ithombe intathu-ke u-12 lona-ke u-17 phakathi nendawo beku-46 ekugcineni. Idate i-26 October 2014, isikhathi u-17:31 nama-seconds awu-14. Kunumber 17, date 26 October 2014, isikhathi u-17:28 nama-seconds awu-29. Bese kuthi u-46, idate nayo u-26/10/2014, kodwa-ke isikhathi asikho. Kodwa-ke okubonayo-ke lana unumber 12 umsolwa-ke umi yedwa kulesa sithombe, uyena-ke yedwa kulesa sithombe. Bese kuthi ku-17 ngishilo-ke ukuthi laphayana unaye-ke umsola wesihlanu. Kodwa-ke uyabona ukuthi ukhona-ke umehluko kwisayizi-ke yawo ama-drags ama-dreads ukuthi-ke ku-12 agcina-ke khona la entanyeni-ke bese kuthi-ke abamade kulesa sithombe u-17 nakuyena-ke u-46 made-ke ama-dreads. Ngase ngisho futhi-ke nokuthi siyabona-ke ku-46 ukuthi-ke kunala agqoke khona-ke ngokwahlukileke kulezi ezimbili iy'thombe u-12 kanye-ke no-17. Yingakho ngishilo-ke ukuthi sibe khona-ke isikhathi noma ebenaso-ke isikhathi sokuthi-ke ashintsheke lokho agqokile. Yingakho sengikhulume ngawo-ke ama-dreads sithi-ke asazi-ke ukuthi-ke nanjengoba ekwazile ukuthi ashintsheke iy'mpahla ay'gqokile-ke ukuthi-ke kwenzekani-ke kubona-ke ama-dreads kule y'thombe ezahlukile ngoba nanjengoba sisho ukuthi ku-12 mafishane kodwa kwezinye iy'thombe made.
My Lord, I further referred to the complexion where I said if one looks at Exhibit J, the first suspect or first intruder is described as having a dark brown, shiny complexion. And I said, my Lord, if you look at the complexion here depicted in photo 12, 17, it is more brownish than light. And that is why I even made a reference, my Lord, to say if one looks at accused 3, now before court, he's much lighter. There's no mistake there. However, if you look at this picture, it is more brownish. And I even said, my Lord, if you look at his complexion from a naked eye and that of accused number 5 that is standing with, it's almost the same. But if you look at them physically now here in court, you can see the split difference. He's much lighter than all the accused, which is a different position here on the date of the incident.
Okunye futhi engikhulumileke ngakho-ke indlela-ke abukeka ngayo-ke ebusweni-ke ekuyindlela-ke futhi nofakazi-ke abachaze ngayo ukuthi-ke omunye walabo abangena-ke endlini babebukeka-ke kanjani-ke bakhulumile-ke ngo-dark brown i-complexion-ke. Uma ukuze sengisebenzisa lesi-ke u-17 isithombe uyabona ukuthi la ame khona-ke nayo umsola wesihlanu ukuthi-ke umahluko awukho-ke khona lapho kungathi-ke bacishe bafaneke indlela ababukeka ngayo. Kodwa uma-ke manje babona-ke manje-ke la enkantolo uyabona ukuthi-ke umahluko mkhona-ke futhi-ke uyena-ke okhanya ukudlula bonke abanye abasolwa la enkantolo umsola wesithathu.
Yes, my Lord, that's what I recall I've said, my Lord.
Thank you, my Lord. There's another, there are other photos again that were compounded to appear contemporaneously, exactly here. I think this has got to do with accused number 3 having I mean, this has got to do with the gun, the perpetrator, the intruder who had a gun in his possession, who had a golden insect in his upper jaw or upper teeth line, which the state says it is accused number 3. Any comment on these two pictures?
My Lord, what I said insofar as this picture, so I didn't make a comparison to this picture insofar as this picture. What I've said about this is that there was an indication or a description of suspect A with a gold teeth incision. And I've said the photo that I referred to in my affidavit is that incision there, which you can see it's a gold teeth incision on the upper lip. So that is insofar as I've commented in the dreadlocks insofar as this picture, but not for it to be compared with this picture. Where I made a comparison, I think it's 2 other pictures which were blur. I even said they are blur, but in my album they are more clearer. So those are the 2 where the court said they must also be put side by side in terms of the blurrity or the visibility of them, my Lord.
Kulesi-ke isithombe-ke akukho la khona-ke engiqhathanise lesi kade ngisiqhathanisa naso-ke lesi ngikhulumile ukuthi bekhona-ke labo bekhuluma khona-ke ukuthi-ke bakunezinyo-ke egolide-ke ngase-ke ngikhuluma-ke ngalo leli liyabonakala lapha kodwa hhayi ukuthi ngiqhathanise lesi sithombe kanye naso-ke lesi sikhona-ke ezinye la engishilo khona ukuthi zona ayicacile-ke la kodwa-ke kumina kwezami iy'thombe zona ziyabonakala.
I further indicated, my Lord, that I do recall that the witnesses like Zandi, for example, Kumala, I know she made a withdrawal statement where she was interviewed to say she never said accused or the first intruder had a gold teeth incision, and to say there were such statements at a later stage where they were saying no, we didn't say that, my Lord.
Futhi-ke ngiyazi ukuthi ikhona-ke iy'tatimende khulukazi yena-ke uZandile Khumalo la-ke abese ehoxisa khona-ke ethi-ke mhlampe-ke noma-ke kube yiphutha-ke angikaze ngikusho-ke lokho ukuthi lo wokuqala owangena wayenezinyo legolide.
Yes, my Lord, that's what I said regarding the picture on the right hand side.
Thank you, Brigadier. You know the reason why we actually came up to the point where we had to exhibit that picture depicted on the right-hand side. It is because of what is contained in your affidavit, which is the following. Photos downloaded taken of the accused by himself, when we're talking about accused number 3, in brackets selfies, matched the description of the suspect who had a firearm with dreadlocks, big eyes, and with a golden teeth. Do you understand? Now I said to you, can you please take us through Exhibit S and show us a photo or photos which have got those type of description. The dreadlocks, we have shown us the dreadlocks. The big eyes, we have tried to show us the big eyes. The golden teeth, you took us to this one. Do you understand? And you are saying this is the context of saying that this is accused number 3. Now the question is, the person that is depicted on the right-hand side, is that accused number 3?
Yes, my lord, in my view, my lord, this is accused 3, and that is the part that I dealt with, my lord, to say in his view, because this point was raised previously, and I said in terms of the angle, if the reservation insofar as accused 3 is concerned, I'll hear him, but I said in my observation, my lord, this is accused 3, and I'm basing this, my lord, in saying, remember the court will recall that I said these pictures were taken collectively based on the investigation. Now, on my investigation, my lord, I did not find any indication that says this person is someone else other than accused 3. That is why the court will remember that the court asked me about 2 individuals which were standing next to accused 3 in some pictures. And I said during the course of the investigation, we were able to establish that those 2 individuals are related to accused number 1. Although they were not involved in this matter, but insofar as this individual, my lord, one could not place him elsewhere as being somebody else, my lord. That's the essence of where the investigation took us.
Just on the shoulders, what is he wearing?
It looks like a string, my lord.
What's it? That bluish
Yes.
color, what is it?
It's a string, my lord, but one cannot see.
String?
Yes,
I
it looks
see.
like a string, my lord. So,
ngithe mina-ke ngolwami-ke uvo-ke ukuthi-ke lona-ke okwisandla hlangothi kwesokudla-ke mina-ke ukubonayo ukuthi uyena-ke umsolo wesithathu futhi-ke kuphenyo-ke akukho la khona-ke uma ngiqhubeka nophenyo la ekutholakale khona noma ekuvele khona-ke ukuthi omunye umuntu lona akusiyena-ke umsolwa wesithathu. Kuyafana-ke nakwesinye isithombe lesi inkantolo bengibuze khona-ke la abanye abalisi ababili bebehlezi lapho ukuthi bawobani, ngasho-ke ukuthi ihlobo zakhe-ke umsolwa wokuqala kodwa akukho okubahlanganisa necala leli.
I've also identified, my lord, pictures where I said accused 3, and I even said with greatest respect to him, one does not intend to offend him, that the eyes are bigger in terms of what I saw in those pictures that I referred to, my lord. So I've referred to those specifically to match what is contained in my affidavit with what was seen in the downloads, my lord.
Zikhona-ke iy'thombe futhi-ke engikhulumile ngazo ngabe ngisho-ke noma ngigcizelela-ke ukuthi lokho ngikusho-ke ngenkulu-ke inhlonipho uma ngikhuluma-ke ngawo-ke amehlo ukuthi ngempela-ke kuyabonakala ukuthi makhulu ukuthi-ke angikusho lokho ngoba-ke ngimdelela kodwa-ke ngisho lokho-ke okukhona-ke kuyitatimende noma indlela ofakazi abasho ngayo.
Yes,
Thank
my
you,
lord.
Brigadier. We may proceed.
Yes, so my lord, we were at the photo that we needed to deal with is photo 47. That's where we were at, my lord.
You had photo bunny?
47.
Yes, listen, as I said initially, it is not me who's taking you through this exercise, because I just wanted you to identify those features there from this photo album. I'm not so sure whether you're done or not.
I suppose, my lord, photo 47, 48 will be the last one, and I'm saying the exercise, and that's why I explained it, my lord. The description, the sentence that Advocate Mnisi referred me to, talks to the description that was given by the people who were inside the house. The people who were inside the house, in describing the first intruder, refers to the clothing, it refers to the type of the top he was wearing, they refer to the top. This is why these pictures, my lord, these downloads are relevant, because somewhere you see the top, but you don't see where it ends. For example, in photo 47 that we will get into, you will see clearly as a collaboration of the previous picture that it is a top, and it matches the description of the color given on the other side, and it is also dated on the same date of the offense. So the pictures that I'm referring to, my lord, are relevant insofar as the portion that Advocate Mnisi referred me, and it relates to the date when this offense were committed, because when I disposed this affidavit, I was giving an indication to the prosecutor in terms of what evidence do we have insofar as accused 3 is concerned, my lord.
Uma ngangenza ke le statement esifungelwe phecelezi ke affidavit lana ngangichaza khona ukuthi ke yini ke esasinayo nomfakazi esasinabo ke uma siqhubeka ngalo ke uphenyo manje ke le ithombe lezi ke ivezayo noma ke engikhuluma ngazo lana ke ethola ukuthi ke uma ofakazi bechaza bayasho ukuthi wayegqokeni wayebukeka kanjani wayenani manje kuzothola ukuthi kwesodwa ke isithombe itop le yabonakala ke kodwa ke kwenye ke kwesilandela isithombe ila ebonakala wonke ukuthi ke ugqokeni ingakho ke ngenza ngalendlela ngenza ngayo.
And it was a request, my lord, that I've said. I did indicate with greatest respect to Advocate Mnisi that I said this is an exercise that we dealt with, but obvious because the question was asked. Now I'm going through it step by step in correlation to the exhibit it referred me to, that is Exhibit J, my affidavit and supporting affidavit, to put context as to why I said what I said in my affidavit, my lord.
Futhi ke ngalendlela engenza ngayo ke bengishilo ke nama ke uma ngikhuluma noma ngisho ke nako Advocate Mnisi ukuthi ke besikhulumela ngayo Exhibit J kanye futhi ke nayo ke iaffidavit yami ukuthi ke ilendlela esizokwenza ngayo ukuthi ke sibuke zonke le ithombe.
Now photo 47, my lords, depicts, and this is also part, it's covered, my lord, I'll refer to this picture because it depicts firstly the date. If you can just go down a little bit, Dr. Spanier. So what is of importance, my lord, is that the date reflected on top is 2014-10-26, which is a date in which this offense was committed.
Okubalekileke idate laphana u2014-10-26 ekuyona idate isigameko lesi esenzeka ngayo.
And then the person on the right, my lord, is accused number 3, and one can see that this khaki top, you can see the waistline, my lord, it ends there. It's a khaki top, as described by some of the witnesses, that the first intruder was wearing a khaki and it was a top. So one can see in this picture that indeed there's a waistline here, my lord.
Nokuthi ke futhi ke kusona ke lesithombe lesike umsola wesithathu ugqoke ke le top ke ekhakhi ekuyitop ke ofakazi abakhulumileke ngayo uyabona ke nokuthi ke la egqoke khona ukuthi ifica noma igcina kuphi.
My lord, one can also see the dreadlocks.
Nama dreadlocks futhi nawo ayabonakala.
But furthermore, my lord, this of pivotal importance, my lord, the complexion, the dark brown complexion. This picture seems to be taken during the day, according to my observation, but the complexion here, as I've referred also as it is the same on the other pictures, that is more brownish than light, my lord, which correlates with the dark brown description given to Warrant Officer Steenkamp by all those people who were inside the house when she interviewed them.
Nokuthi ke ngendlela ke ngibona ngayo noma ngibuka ngayo ukuthi kwakusemini kathi ke isithombe lesi sithwetshula nokuthi ke futhi ke okubalekile ke uma ubheka noma ubuka ke ubuso bakhe ke nangendlela ke ufakazi abasho ngayo ke mayelana naloku qala ke owangena nkathi bekhuluma naye ke uWarrant Officer Steenkamp.
Now, my lord, photo 48 is basically the same picture, it's the same location. The only difference between photo 47 and 48 is that in photo 47, accused 3 is drinking, he has got a can in his mouth. Then in photo 48, if perhaps we can get to it, he's holding the can on his hand, but you can still see him and the same type of clothing, and the same gentleman that he's standing with on photo 47 is still with him, although there are other people around. But insofar as picture 48, it's just the two of them, my lord, but wearing the same clothing with dreadlocks, and if one looks at the complexion in this picture, my lord, it's also more brownish than light, my lord.
Okunye futhi ke kule ithombe ke embili ke umehluko ke obonakalayo noma okhona ke la ukuthi kusona ke isithombe lesi ke u47 ekuyisona lesi ke ukuthi ke ikandleli ke lisemlonyeni, yebo bakhona uyena ke uyena ke nalo yamlisa amenayo ku48, kodwa ke bakhona ke abanye, kodwa ke ku48 ikandlela oliphethe esandleni.
Yes, my lord. So these would have been the pictures that I took into account, my lord.
Yizona-ke lezi iy'thombe-ke engayiveza noma
Thank you,
engathi
Nagadi.
ngiveza.
Yeah, and that is insofar as accused, the first intruder, my lord. Obviously, when we dealt with other issues of the monies, the farms, one expanded on this, but confining myself to the question that Advocate Mnisi asked me, this is what I looked at, my lord.
Kulokhu-ke angibuze kona-ke Advocate Mnisi, yabo kukhona-ke okunye imali-ke noma-ke iy'thombe-ke kodwa kulokhu engibuze kona-ke izona lezi iy'thombe.
Thank you. Now, we further say in the affidavit, photos were equally found of the murder weapon used in the murder of Senzo Meniwa. Now, you would recall that in the course of my cross-examination, I put to you a question that said that in your evidence, in your evidence somewhere, can't remember whether it was in evidence in chief or cross-examination, you made mention of the fact that the weapon or the firearm that was used when Senzo was killed was found in the download or is depicted in the downloads of accused number 3's phone, not so?
So, my lord, I understood the context to be the following, that the question was referring to what I've said before court. And I said, I don't recall having said that in court. But I even said to Advocate Mnisi that perhaps you are referring to the statement, because I knew that in my statement, such assertion is contained. But where we were differing is that in court, that evidence I was not made to lead that evidence, my lord.
Uma besikhuluma-ke ngakho-ke lokhu ukuthi-ke iy'thombe lesi-ke lezi-ke isibhamu-ke noma lesi ekusola ukuthi isona-ke esabulala-ke sikhona-ke kulama-downloads. Mina-ke ngithe ukuthi la enkantolo-ke lokho ngikhulumile ngakho umehluko bekuwukuthi-ke kulokho noma-ke kwi-statement noma-ke i-affidavit kodwa hhayi ukuthi-ke kwakhulunywa khona la enkantolo.
Thank you. Now, on page 83, the proceedings of the 24th of January 2024. What month is this? December, ne?
This is December, yeah.
Yes, 24/01/2024. That's I think that was cross-examination. When you've been cross-examined by Mr. Ngomizulu, I think that was within the trial, if my memory serves me well. I'm not so sure, but that is the record of the 24th of, the date of the 24th of January 2024, page 83, where you say at at line number 8, thus photos were equally found of the murder weapon used in the murder of Senzo Meyiwa. That is exactly what I was referring to when I said to you that's something that you said here at court, but nonetheless it is stated there. Now, when you say photos were equally found in the downloads, photos of the murder weapon were equally found in the downloads of accused number 3's cell phone, can you please take us to that photo that depicts the firearm that accused number that the intruder had when he accosted the Kumalus, which was found in the downloads of the photos of accused in the photos of the downloads of accused number 3's phone.
Yes, my lord. So,
yes.
Yes, no, I'll take you there quickly, my lord.
Please.
So my response, I just want to deal with this part of the proceedings, my lord. My understanding of the question of when did I say that, my understanding was that I was being referred to the evidence in chief in the main trial, because that's how I understood the question. It wasn't to say in my proceeding during the trial within trial, and I answered in that context, my lord. That's why I said perhaps in my statement, but yes, if the record says that, my lord, I don't dispute it. I have a recollection of what the record is saying. But going to the question, my lord, if you look at, and this is my observation, my lord, it's mine, it's my observation, that photo number 38 depicts a rifle and a pistol, my lord. Now, in my observation, my lord, this pistol matches or looks similar to the one that was found, my lord, as the firearm that discharged the bullet that was found at the crime scene, my lord.
Uma sibuka ke isithombe 38 kuna rifle ke laphana kanye futhi nayo ke i-pistol yona ke i-pistol leyo ke ehlangana ke noma ke ebukeka ke noma ke ifana ke ngamashiki naleyo ke eyatholakala ukuthi ke isona ke isibhamu ekuyisona esadubula kathi ke usenzo eshona.
Now, Brigadier, are you aware that what you stated here misled the magistrate? Because you are saying to the magistrate, look, sir, photos of the firearm that was used, or a photo of the firearm that was used in the killing of Senzo Meiwa was found in the downloads of accused number 3's cell phone. You don't say to the magistrate that, in my observation, in my view, there's a photo that I saw in the downloads of accused number 3's cell phone that resembles, but you're stating this as a matter of fact. This is perjury. You misled the magistrate.
Please, my lord, I think counsel it's maybe putting it in much more robust language. The witness, to distinguish between what your view is in an affidavit and what the fact is, we submit, my lord, that it's putting it much stronger to say that this witness misled the magistrate. He has repeatedly said this is just a summary, and he maintains that photo 38, in his view, it's the firearm that was found in accused number 3's possession. There's nothing wrong in that. There's no basis, my lord, to submit that, as counsel puts it, that he misled the magistrate. We submit that question ought to be disallowed.
As it is the court, my lord. Look, I am referring to what this witness told the magistrate in his affidavit. I'm not citing this. The state is then suggesting that the summary must also not be factual. A person can say whatever that he wants to say in a summary, even if it is not factual. This simply constitutes perjury. Somebody lied under oath, my lord. You cannot go and tell the magistrate that photos, as a matter of fact, were found, or a photo was found that killed Senzo Meiwa in the downloads of accused number 3's phone. What did the magistrate have to do with it? Then the magistrate says, no, there's a exceptionally strong case against this accused or against this person that I need to sign this warrant against or for. This totally misled the magistrate. That is my submission, and I'm putting it to you, Brigadier, that this information that is contained in this affidavit, which is something that was made under oath, was misleading, because there are no photos that you can point out exactly and say in Exhibit S that this firearm, it's a fact that it is a firearm that was used in the killing of Senzo Meiwa, and it was found in the downloads of accused number 3's phone. Are you able to do that without speculation?
We've raised our objection and we stand by it. The witness never said he's changing his position as far as that is concerned. He still maintains it's his view that this pistol that is displayed in photo 38 is the one that was found in accused number 3's possession. The only difference, as counsel puts it, is that in the affidavit he stated it as a fact, whereas he's now saying in his view. There's no difference between he's not really changing position.
Is that the pistol which is depicted there?
Yes, my lord.
Is there any resemblance to the pistol which this court handed over to Mr. Peterson to go and examine?
In my view, my lord,
Is there any resemblance?
there is, my
Or
lord.
there is none whatsoever?
No, there is resemblance, my lord.
What is that, how do you describe that pistol or firearm or gun? What is it?
It's a 9mm semi-automatic pistol, my lord.
9 millimeter, wait.
Sorry.
9 millimeter
Semi-automatic pistol, my lord.
semi-automatic pistol.
Yes.
And the one which is allegedly supposed to have been used in the...
It is also a 9mm and black in color as well, my lord. 9mm pistol. I think it may have just another addition in terms of the specification, but in essence it's a 9mm semi-automatic pistol as well, my lord.
Nayo-ke le ekuyona-ke kusola ukuthi ulala-ke usenzo nayo i-9mm automatic pistol-ke mhlambe ngakhona-ke nje okungengezwanga khona lapho kodwa nayo-ke i-9mm nayo-ke futhi imnyama ngombala. Umehluko befuna ukwazi-ke ukuthi lesibhamu lesi-ke khona yini ukufana noma-ke ukwehluka phakathi kwaso nalesi esanikezwa yena-ke uMr Peterson ukuthi ahambe ayoqhathanisa-ke uthi ubrigadier umephendula cha akukho ukwehluka.
Sorry, it's photo number?
38, my lord.
38, okay.
Yes.
Yes, Mr. Miss.
Thank you, Brigadier.
So perhaps, my lord, if I can just, because I have to get Minister said certain things and I didn't say.
I yet have to answer my question. Which question are you answering now? I haven't asked my question.
No, you did.
The court said to me, yes, Advocate Nisi, and then I said to you, yes, Brigadier. This is an interlude to my next question, and then you are answering now. Which question are you answering?
I'm answering your previous question where you said I must
okay, you still want to, okay.
I don't know whether you want me to leave it because you made a session about me identifying this photo
Yeah, no,
that the
but
court is.
the court
Are we
says to
moving
me,
on?
yes, it means I need to proceed.
All right. Okay.
Yeah.
Yeah, what do you want to say, sir?
My lord, yes, I wanted to say firstly, my lord, if and this is the part that I've been saying to Advocate Ndisi more than one, my lord. When you look at the statement that I've made, if you're going to pinpoint certain things and you don't look at it its entirety, there will be such assertions that are made which are not accurate, my lord. And I beg to differ with him when he said the magistrate was misled. That's not true, my lord.
Engifuna ukusho lana ukuthi-ke uma ngabe uzothi-ke uma ubuka-ke izinto-ke ubuke nje ingxenye ethize-ke kodwa-ke ungabuki konke kuphelele-ke yila khona-ke uzoba ney'nkulumo-ke ey'fana nazo-ke lezi la asho khona-ke u-Advocate Mnisi ukuthi-ke imantshi yakhohliswa-ke ukuthi-ke angizange ngikhulume-ke iqiniso kwimantshi engasilona-ke iqiniso lokho akushiwo.
If you look at the statement, my lord, where I'm making this assumption that is coming from me, it is so clearly stated, my lord, because when we deal with this firearm, I was specific prior to this download, my lord, where the specification of experts who dealt with the firearm, I dealt with it in the statement to say the firearm, how it was seized, and what was done by the experts. That, my lord, is factual. That's where you find the specs, because I do indicate that the firearm seized under Cleveland 96 of 2015, which is linked to accused 3, was tested, and the forensic report then confirmed that it was the same firearm that was discharged. So those are the facts, my lord. But in addition to that, as an investigating officer, I give my own view in the case, my lord, insofar as the evidence that I collected. So there is no misunderstanding in terms of what I've said, because I've never said in this sentence that it was ballistic or scientifically proven, my lord, that this firearm...
May I go and see, I'm sorry, Brigadier Kininam. Accused number 3 is raising his hand. Probably there's something that he wants to bring to my attention. In the meantime, Brigadier can proceed with his explanation.
All right, my lord. There is nowhere, my lord, where I said there is scientific or correlation by experts that this picture 100% correlates with the murder weapon. I'm stating what I saw, as I've been stating, my lord, insofar as other pictures and the bags of money. It's what I'm seeing. But now, if the question will arise and say, but can you say factually that this bag of money was in the same position? That I'm going to rely on what I see, my lord. So all I'm saying is that there was no misleading. It was chain of evidence that I was referring to, and where there were specifics, I was very specific, my lord, to say ballistic report give this indication. If you read this sentence, there's nowhere where I say this is a scientific findings, my lord.
Uma ngabe ufunda-ke lana-ke kuloko okubhaliwe la, akukho la khona-ke engishoyo khona-ke ukuthi manje uma kwenziwa ucwaningo kwabuya-ke nesinqumo esithi lesi isibhamu isona-ke ngithi-ke kuloko mina-ke engikubonayo futhi-ke uma ngiqhubekeka ngalo uphenyo olwenziwa-ke ngoba-ke yebo kunala ngishoyo noma-ke kubhaliwe khona ukuthi isibhamu esathathwa-ke ngaphansi ko-Cleveland 962 ka-2015 kwahanjwa sayocwaningwa. Uma sekubuywa-ke kwatholakala ukuthi ngempela leso sibhamu leso isona-ke isibhamu esasetshenziswa ukubulawa kukaSenzo, kodwa la akukho la ngisho khona ukuthi lesi ekulesi sithombe yisona isibhamu kodwa-ke ngisho nje lokhu mina engikubonayo futhi ngokuqhubeka kophenyo.
Furthermore, my lord, I did indicate previously that insofar as the process that I embarked on when I was doing this application, my lord, what was done, and I indicated to Albert Minister that this is how things are done. This is how I did it in this matter. In preparation of, after this application, my lord, statement was signed and commissioned. The docket itself, my lord, in its entirety, because I even indicated that before it went to this court, it was first presented to the DPP, which then issued an indictment. Subsequent to that, my lord, I took the docket, not the statement, where, for example, the NPA, when they deal with it and subsequently the magistrate, will be simply looking at a statement without supporting document. The entire docket was taken where the advocate, I even indicated that the advocate Stradom, who signed the warrant and subsequently not authorized by the magistrate. The docket was there. That's how it was done. So the evidence insofar as what was contained in the docket was not withheld. So there wouldn't be misleadings, my lord, because what I refer to is attached on the docket. In other words, the downloadings, the ballistic aspect of what the expert is saying, and all the issues that I referred to, including the confessions, everything that is contained in my statement, my lord, was presented to the court, and then I received it back when the warrants were authorized. So the entire docket. So there was no withholding of information. That's not how I dealt with this application.
Akukho la khona-ke kunolwazi oluthize olwakhoza khona-ke ukuthi lolu-ke angeke ludluliselwe-ke ukuthi-ke u-advocate Stradom asesayinda-ke manje leyo warrant noma-ke incwadi-ke igunyaziswa ukuboshwa-ke kwabo-ke abasolwa. Akukho okwagodla-ke banikezwa konke-ke nedokodo, hhayi ukuthi nje kwakhishwa istatement kuphela idokodo lase liyagcinwa-ke lona-ke, kodwa bonke ubufakazi ukuthi-ke ama-ballistic athini, lobu bufakazi buthini, konke lokho kwanikezwa-ke, hhayi ukuthi-ke inkantolo yakhohliswa, kodwa bonke-ke ubufakazi noma konke okwakukulona idokodo kwandluliswa ngaphambili kokuthi-ke incwadi lena isayindwe-ke noma-ke phecelezi i-warrant.
Yes, I'm raising this point, my lord, to indicate that there was no misleading or perjury or anything, because the evidence was presented in its entirety, the entire docket with what it contains, including the indictment and all supporting documents, confessions that we dealt with, my lord, everything that we dealt with insofar as being evidence. That is how it was taken, and then it was received back then with authorization, my lord.
Ngikusho lokho-ke ukuveza nokutshengisa-ke ukuthi-ke akukho okwagodlwa-ke, konke kwalethwa-ke noma kwasiwa-ke ngaphambili, bonke ubufakazi obabukhona-ke, iy'tatimende, ukugonyuluka, konke nje ubufakazi obabukhona-ke bahanjiswa. Uma yasayindwa-ke incwadi ngase ngikuthola konke futhi kwabuyiselwa kumina.
And most importantly, my lord, this statement, this is the last aspect. This statement that Advocate Miniti seems to suggest that there was a perjury on it is dated 23 October 2020. The indictment, my lord, to arraign this accused, and that goes for accused number 3, is dated 21 October 2020. So the DPP, the NPA, already made a decision that these accused must be indicted. Hence I've said, my lord, when I made this application, it was just a process of bringing them to court. So there was already a decision, my lord, taken, covering all this aspect that I spoke about, my lord.
Istatement lesakhuluma ngaso-ke u-advocate Mnisi la athi khona-ke imantshi-ke yakhohliswa-ke akuzange kudalilwe konke-ke, i-date yakhona-ke yi-23 zika-October 2020, bese kuthi la khona-ke isinqumo sasesithathiwe-ke khona ukuthi-ke abasuke lawa baboshwe kwakungeyi-21 zika-October 2020.
Yes, my lord, that's the aspect I wanted to touch base on.
Thank you, Brigadier. It does not end up there. On the 20th of November 2020,
Okay, where are we in, and what paragraph now are we at, my lord?
I mean another statement, A227.
Okay, I'll have to get to it then.
A227. You tell me when you get it.
Yes, just if you can just bear with me a bit.
Statement commissioned on the 20th of November 2020 by Detective Sergeant BB.
Yes, my lord.
Thank you.
I've got it.
It has not enough there. Again, on the, as I'm saying, on the 20th of November 2020. You're also saying photos were equally, okay, on page 6 of 10. 6 of 10, as you were trying to explain on paragraph 3.3, which is written in both letters, Mtobisi Prince Mnube, nickname Carlos. On the very last paragraph, you are saying photos were equally found of the murder weapon that was used in the murder of Senzo Meyiwa. Now, photos which were downloaded from accused number 3's phone. A photo containing the exact bag of money similar to the one found in Miss Kelly Kumalo's phone was also found. There is also another selfie that was taken by the phone of this accused, which shows him having a gold tooth. This gold tooth was one of the things that was noted by the witnesses. It's imperative to mention that this accused currently does not have the gold teeth as well as the dreadlocks, but evidence shows that he had both in 2014, October the 26th. Now, insofar as you saying that there were photos which were found on the murder of the murder weapon that was used in the murder of Senzo Meyiwa, which photos were found from the downloads that were extracted from accused number 3's phone. That's a lie. This is yet another lie in a different statement.
But we've already dealt with that aspect in the previous statement, Exhibit ZZ. We raised in the same objection again, and I think it's discourteous to a witness. I'm not even going to repeat the words that Advocate Nisi used, but we think it's discourteous to put that to a witness.
As it pleases the court, my lord, I might have used the word lie instead of using the word misleading, but the consequences are the same. Whether I say drinking water, whether I say aqua, and those who know what aqua is, they just mean the same thing. Whether I say a black person, whether I say African, those who know, they know that they mean the very same thing. The consequences are the same. But the gist of what I'm saying here is the magistrate was misled into believing that, actually I'm not talking about the magistrate. The affidavit says that there were photos of the murder weapon that were found in accused number 3's downloads, or on the phone of accused number 3's downloads. Now, where are those photos? Brigadier says, no, it is my view. There is nowhere where it is stated in his statement says that this is my view. It says this is stated as a matter of fact. This was just to demonstrate, said that there was consistency in the act of misleading in your affidavit, and for what purpose is yet to be seen.
My lord, I don't know how really how many times must I deal with the same aspect? Because it seems Advocate Nisi wants to interpret the statement at dispose in a way that suits him. I've indicated, and this is supported by the exercise we've dealt with this morning. I've shown photos of the gold teeth incision, and this is why I caution Advocate Nisi that you need to take this exercise in its totality. I was making a statement for a certain purpose, covering the evidence in totality. And this assertion that is going to, it's the same thing that I tried to question him earlier on, my lord, to say you can't look at one picture and expect to find this. You need to look at the exercise that we did in totality. And if you do that, my lord, you will realize that what I've mentioned here is contained in those pictures, even though they are different numbers and taken at a different time. Now, insofar as the firearm is concerned, my lord, there's no misleading and there's no lie, as Advocate Nisi puts it, and I say it with greatest respect, disrespectfully and so much aggressive. Because how do you mislead, my lord, when there's already a forensic report that says this firearm that was seized under Cleveland 96 of 2015 links the firearm that discharged the bullet that was found at the crime scene? This is scientific forensic fact. It was there before I made the statement. Now, investigation, putting that forensic finding, my lord, investigation on my side leads me to identify accused 3 as the first intruder that was in the house, and subsequently investigation implicates him being in possession of the firearm that was seized and linked to this offense. Subsequent to that, my lord, downloadings that are coming from the cell phone that was seized from accused 3 together with this firearm on the very same day. Firearms are found. The firearm is found that I refer to, but in that, my lord, I refer to photos in plural form to simplify it with the S of all these things that I indicate. So Advocate Nisi now conveniently select a particular narrative that he wants to put to say is misleading, and that is incorrect, my lord. I went through this exercise, and even when he said to me this is not what he asked me to do, I indicated, my lord, over and over again, that is to show that the photos that I referred to in my statement were covered in this total picture. So you need to look at the totality of the picture, not in one isolation, to say when you say photos, you are now giving an inference of saying I want 10 photos of the firearm. You ignore that in this presentation I'm talking about gold tooth, I'm talking about red locks, I'm talking about the firearm, and you have this, my lord. It is in this exhibit S, I think, where these things are actually captured. So I don't know how best can I explain now to give an insinuation or a suggestion that someone was misled. It's incorrect, my lord, and that is why I'm saying you need to flow this thing, you need to take it in its correlation of events. First, the presentation is done to the DPP, which is in possession of the entire docket. There's no misleading there. They are able to go into the docket, and that is why, despite what I was praying for when we dealt with Kelly, my lord, they took a certain position and we dealt with it. The evidence is before them. Subsequent to that, we take the matter to the courts. The evidence is before them, supported. That is how it was done. How is then, my lord, anyone misled when all the evidence that I'm referring to is in the docket? Nowhere did I say there's scientific support of this. I'm referring to my statement. It's a statement that was signed by me to say this matter opened because I see similarities, my lord. How I see similarities, as a police officer, I was trained in the usage of firearm. As much as I'm not an expert, but I'm able to identify that this is a rifle, this is a 9mm, this is a pistol. We are able to see those similarities. So the identification is based on me, and I never attributed that, my lord, to anyone insofar as this statement is concerned.
Ngazi-ke ukuthi lana-ke ukukhohlisa-ke imantshi ukuthi-ke kwenzeka kanjani-ke uma ngikushilo-ke lokhu ukuthi-ke bonke ubufakazi idokodo-ke nako konke kwakungaphakathi kulona-ke sekuyosayindwa uyena-ke u-advocate wasayinda sekuyiwa kuyona-ke imantshi ukuthi konke kwakulapho akukho engakugodla-ke ngithi cha lokhu angikuhambisi angikuyise enkantolo. Angazi-ke ukuthi manje kwenzeka kanjani-ke ukuthi-ke yakhohliswa-ke imantshi, nokuthi futhi-ke uphenyo-ke elangiholela kuyena-ke umsola wesithathu ukuthi-ke ngithi-ke uyena-ke noma ngimhlanganise-ke nokuthi uyena-ke owayengumsola wokuqala owangena laphayana, nokuthi futhi-ke uma ngaba isibhamu lesi-ke sitholakala kulela icala lase-Cleveland, uma manje sesiyocwaninga-ke kwatholakala ukuthi isona-ke isibhamu leso esakhipha inhlamvu leyo eyatholakala khona-ke kuleli cala eliphambi kwenkantolo-ke manje. Ingakho ngishilo-ke no-advocate umnisi ukuthi-ke lolu daba lolu-ke akangabheki-ke lokhu okuthize yena-ke akufunayo, kodwa-ke akabheke konke lokhu engikhulume ngako. Ingakho-ke besibuka le y'thombe ebesiyibuka-ke lana, ngoba-ke ingafuni-ke ukuthi-ke isithombe esithizeni esizotshengisa lokhu-ke akufunayo, kodwa-ke asiyibuke siyibheke zonke iy'thombe.
Thank you, Brigadier. Now, I heard you saying in your testimony, again, I can't remember whether it was in cross-examination or in your evidence in chief, but it was in this session, not in a trial within a trial, it was in this session, where you made mention of the fact that you were not aware about the testimony of Mrs. Pinky Vitilinga, not so?
My Lord, what I've said is
Yes.
that I was not in court. That's how I recall the events. That I'm aware that she testified, but all I said is that the actual words that she used when she was in court, because I was not in court, my Lord. That's what I've said. It was in that context.
Ngaye uPinky Vitilinga ukuthi bengazi ukuthi-ke uzile enkantolo ezokuthula ubufakazi,
Yeah.
kodwa-ke ngangekho-ke la enkantolo ukuthi-ke ngazwe noma ngizwe ukuthi yini ayisho la enkantolo.
Thank you, Brigadier. Actually, you said, I'm just paraphrasing you. You said you were not aware of the cell phone records of accused number of the cell phone records of accused number 3, not so?
No, so let's put it in the right context, my Lord. I've
Yes.
said, prior to Miss Vettelingham coming to testify,
Yes.
I was not aware of the cell phone records that covers the period of 26 October 2014.
Yes.
We had cell phone records that I think were starting in November going upwards, and I said when she was in this court, that's when I became aware of those cell phones, which were then subsequently made available to us, my Lord. Cell phone records, sorry.
Engikushilo-ke ukuthi-ke ngangingazi-ke ngawo-ke ama-cellphone records akhe-ke umsola wesithathu mayelana nesikhathi-ke 26 October 2014, kodwa-ke kuzokwenzeka lokho ukuthi ngazi-ke nkathi-ke eselana enkantolo ethula ubufakazi bakhe-ke yena uMiss Pinky Vitilinga.
So the first time you got to be aware that there are cell phone records which cover the period also of the 26th of October 2014 as they relate to accused number 3. It was when Mrs. Vitilingham was testifying in court.
My Lord, when I said when she was testifying, so how it works, an advocate minister knows. There will be a consultation with the state advocate, and then obviously then the witness will testify. So I'm saying it was around that period, prior to her coming to give evidence in court, I was not aware. So I was aware around that time when they were consulting with state advocate, that it was then somehow brought to my attention that there is new cell phone records that relates to the specific date of the incident, because we didn't have, my Lord. That is why if you look at the request I gave to Kenneth Stein, nowhere does he cover the period of the 26th of October in his analysis 2014, my Lord.
U-advocate umnisi uyakwazi-ke lokho ukuthi kusebenza kanjani-ke ukuthi ngaphambi kokuthi ufakazi-ke eze enkantolo ezokuthula ubufakazi bakhe-ke ukuthi uhlala phansi-ke nombuso enze lokhu okubizwa ngokuthi phecelezi-ke i-consultation. Manje ngithi-ke mina-ke ngikwazi ngaleso sikhathi-ke ngokuthi ngaphambi kokuthi aze enkantolo ezokuthula ubufakazi bakhe-ke ukuthi bakusenala amarekhodi amasha-ke manje ama-cellphone sondele kulesa sikhathi lesiya sange-26 October 2014, kodwa-ke kuyena-ke uKenneth Stein lokho angizange ngikuthola, kodwa kuyena uPinky Vitilinga.
Thank you, Brigadier. Let me ease your mind. The records of accused number 3's cell phone, as they also cover the period of that 26th of October 2014, had already been disclosed to the defense at the very inception of this trial. So, it strikes me very strange in terms of the nature of your investigation to say that you were not even aware of those records.
That cannot be correct, my lord.
For a different case,
Yes.
I mean, I can remember the evidence.
Yes.
Not for this case.
Indeed.
Different case.
The records that were disclosed as the witness testified were those ones from the from November 2014. my lord.
I did not get the gist of the objection, my lord, about the disclosure of
Yeah, they say the objection is not clear, Mr. Baloi.
Yes, indeed.
maybe I did not hear the statement. It was something distracted me.
Well,
Yes.
the proposition that the cell phone records of accused number 3 covering the period 26 October 2014 were already disclosed at the time when there was a general disclosure. We objecting to that, and the basis of the objection is that that is not correct, my lord.
As it is a court, my lord, it is incorrect to say that those records were already disclosed to the defense at the time when Mrs. Pinky Vitilingam was testifying. I became aware of that Section 205 record when I was preparing for this trial. And they were contained in Cleveland case, in yellow pages. Now the question is, if really this case was investigated to the manner in which it is to be assumed that it was investigated, how can then Brigadier Kininda say that he was not aware about this so important piece of evidence? When it was disclosed to me, I think last year, May. Thank you, my lord. That's the question that I'm directing it to. I'm not lying to court. I won't mislead the court. That's the question that I'm directing to the Brigadier. I don't know if the state would also want to clarify that as well.
My lord, that cannot be true. It's absolutely not correct. I think one can even take it to the greatest form that it is misleading to say that, to say the least. It's not true, and if that is assertion that it is the truth, then it's misleading. Because the docket is indexed, my lord. When you get evidence, you index it. What was found initially, my lord, and I know we dealt with this part with the forensic team and the state advocate, was that the first records that were applied for, insofar as the Cleveland case is concerned, Advocate Minister is correct in that part, only started in November. I think that's why he's making November. Those are the ones that we were able to discover during the course of the investigation, and those are the ones that were disclosed to them. We had no knowledge of the second bunch of records. Why did we have a knowledge? Did not have a knowledge, my lord? They were applied differently. Even if you look at the reference number of what you call the case file, the first bundle that we disclosed had a different case file than the one that was discovered by Pinky Vetillingham. So it was not records that were available. For some reason, my lord, they were kept away from us. It is through the exercise with Pinky Vetillingham when she was asked to conduct a search on the number that this other set came up. When it then came up, my lord, that's why I refer that it came up around the period of consultation and subsequent to her evidence. Then, during that time, my lord, they were then disclosed to the defense for the first time, and we filed them in the docket. So the assertion that they were given to the defense prior to the commencement of this trial, my lord, if they have it, then they don't have it from us, my lord, because the docket does not have such a recollection recordings, first of all, and that goes to the cell phone analyst, Kenneth Stein, who analyzed these records. That is why, my lord, the person who dealt with this is Kenneth House, because they came around during his period. Kenneth Stein did not have access to this, and the court will recall that part of the exercise that I've asked him to do when Kenneth Stein started as a cell phone analyst, my lord, was the following, and I've dealt with this part. First, I said, this is what is contained in the docket in terms of the cell phone data. Authenticate it. Secondly, I said, he, as a cell phone analyst, because I'm not an expert, he must go and authenticate what we have in relation to what he finds in the database of the police and the service providers. And he came back and said, what we have here, this is what I have, so I can authenticate it. Nowhere, my lord, even himself, was he able to discover these records that mysteriously were kept hidden somehow, my lord, and surfaced when the expert then came to testify. So that assertion is not correct. That is how things unfolded, and they were authenticated. They were not there. So we investigated, my lord. They were not made available. They were not in the face of what we would have uncovered during the investigation.
Kuloba kushoyo-ke u-advocate-ke ngasho ukuthi kona-ke akusona-ke iqiniso, ikona-ke esengaqhubeka ngiye phambili ngithi-ke ikona-ke ukukhohlisako ukuthi-ke bakuthola bona-ke ngaphambilini kwesikhathi lama records amasha uPinky Vitelingam akhulume ngawo abawatholanga kuthina-ke singamaphoyisa futhi-ke lokhu kuzovela-ke ngesikhathi sakhe-ke uLieutenant Colonel Coase ngesikhathi-ke ngicela yena-ke uLieutenant Colonel Steyn le mininingwane noma-ke le information wayengenayo-ke imininingwane leli eyayigodliwe-ke kuthina noma-ke sasingazange siyinikwe-ke kodwa eyazovela-ke uma ngabe yena-ke uMiss Pinky Vitelingam esethula ubufakazi bakhe.
As it pleases the court, my lord, I'm going to request for a short adjournment. It's almost 20 minutes to lunchtime. I'm just about to wrap my cross-examination. However, I still need to pursue this point, my lord. I want to introduce those that record that is being disputed or denied by the state, that it was made available to us at the very inception of this trial, actually even before the accused were made to plead to these charges. I want to introduce it as a fact, something that is tangible. So I would request that we take an early adjournment. So I'll go prepare them and then I'll come present them at 2 o'clock, my lord. When I come and finalize.
We've got a list here of all the exhibits in this trial. Don't we have some? All.
Yes, there
And
is
then
a list of
from
exhibits.
1, I think, up to 170 something. What was the citation? Meaning, in other words, Mr. Mnisi, the very record you say was disclosed,
Yes.
it will be in the exhibits which are given to the court. Unless I was not given that exhibit. If I was given that exhibit, there is a list
Yes, ma'am.
where you just have to read the list and you see
Yes.
evidence of so and so.
Yes.
Yeah, so what's the problem? Why should we not just go and inspect that
Madam,
list?
with due respect, madam, I'm not talking about the list
What are you talking
of
about?
exhibits that had already been handed over to court. I'm talking about disclosure, the information that was handed to us by the state when we were supposed to prepare or when we had to prepare for the trial. I'm talking about that information.
I hear you. Are you saying the state used evidence which they never disclosed? To the court, in other words.
No, my lord. I
What are
never
you
said
saying?
it. I am saying, my lord. I am saying, my lord.
Yeah.
Because the brigadier said in his evidence
Yeah.
that he became aware of the record of the cell phone record of accused number 3 upon the testimony of Mrs. Vitelingam. And then I'm saying to him, no, but it cannot be so because we already had that record when we had to prepare, when we had to start to prepare for this trial. In other words, that record has been there even before Ms. Pinky Vitelingam could come and testify. And then the brigadier says no. Then if we have that record, they don't know where we got it from.
Okay, that's agenda.
Thank you, my lord.
Just before Jen, just so that there's no misunderstanding, the brigadier refers to the cell phone records of accused number 3 that covers the period 26 October 2014.
I'm talking about that as well. Thank you.
Which records are supposed to have prescribed?
Well, the records were there. They were asked by the previous team, my lord, in the other case, but not disclosed to
Okay, fine.
the current team.
We come back at what time? 2 o'clock. Okay.